Hello and welcome to Real Estate Today. I'm your host, Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties. And today I am here with Kerstan of Essential Legal Services. It's a pleasure to be here, as always. Yeah. So today's topic is quiet title. What do you do when you have title issues that prevent you from selling your property? Because different things come up. So Kirsten's going to tell us a little bit about that.
Yes, it's a kind of another overlap between real property, the sale and transfer of property, and sometimes things that lead to the impediment of sale. Mm-hmm. And one of those that often comes up, and I often get referrals from agents wanting to help or assist a resident selling their property, is that they cannot obtain their funding for it, or they cannot obtain their title insurance policy required by the bank for it because the title record is dirty.
Right, it's clouded.
It's called clouded title, correct.
Right.
And when we quiet title, we quiet the noise behind the cloud. We're going to clean it through a court order in a judicial process. So yes, that's when I typically will have my clients come in the door and they will say that there's something that happened to the record. And we just need to know that every time there is a transfer of ownership, it is recorded. And there's a chain that is formed over time. When they find that kink in the chain, that is when you're typically going to see it flare up. And how do those kinks occur? Well, they happen for many reasons. You can have family members that create multiple deeds. Some record, some don't record. Mm-hmm. You can have family members that pass away and they can't find their heir and they haven't maybe provided enough notice to the heir, and they come back and find that they've transferred their beneficial interest in that property. Oh. You can find the county messing up the recording, putting things on record that shouldn't be there, or putting things that should be there in somebody else's file, right? And you have to clean that up. You can have old liens, construction liens, mechanics lien, judgment liens on properties that have not been paid or released. We also can have, I'm trying to think of some of the other things, easement issues.
Yeah.
And those come up a lot where you have different types of easements that have been granted for use of property, not properly recorded or taken away. And so who has right to the use of that? And that also can go through a quiet title action. It's an equitable action under NRS 40.010. And we start that process usually by having a person who believes I am the rightful owner. It's me. And the reason that I have a rightful ownership is A, B, and C. There's going to be a couple presumptions that are the court will have. The first being that documents that are recorded will presume to be valid. And so then the plaintiff, if they don't have the correct recorded instrument, will have to prove by clear and competent evidence that even though it wasn't recorded, it was still supposed to be there. So it's a higher standard than the preponderance of evidence, which is typically used. So deference will be given to recorded instruments. Then you have to do some search, usually with a title company. Mm-hmm. They check the chain and they figure out who needs to be in this action. Well, everyone who touches and concerns that real property will need to be notified of this quiet title action, and that will include mortgage companies and lenders.
Right.
And that can be difficult because you have a lot of assignments from mortgage company to mortgage company, and sometimes those assignments are even unclear. So you just it's better to throw everyone in and settle it all than to leave anybody out. It could be the neighbor that you're in dispute with. It could be the person who believes they're the rightful buyer, but it should have been in your name instead of the person who sold it. All of those people will need to be included in the litigation. Sometimes it can be an informal proceeding, so you shouldn't always be nervous if you have to do a quiet title action, because sometimes it's just the title company wants something cleared up and everyone you notice really has no skin in the game. They're like, it's not my property, I don't even want it. But because there's an apparent look that it could be. They just want it to clearly be on record that it is not their property. So we get a lot of people who will stipulate and say it's not my property. You file those types of stipulations with the court, or some people just never enter the action and they get a default judgment against them as to the property not being there. So the process can be expedited. The ones that are long are, again, the ones that are heavily contested.
Right.
We saw a lot of those when you had the HOA foreclosures here.
So many of them.
Yes.
Where people bought the properties through the HOA foreclosure process, and then everybody, the previous owner thinks they own it. The mortgage company feels they have a claim.
Right. And that case went up to the Supreme Court, over to the federal court. So, and you can imagine there were zombie properties that just were hanging out there with nobody being able to sell it because they were caught up in,
they didn't have litigation. Yeah, they had actual title, but not marketable title, which, if you cannot get title insurance, if you cannot get a mortgage, it makes it very, very difficult.
That's right. So, and that is a big difference between marketable title, right? The property value of your home becomes quite low because any buyer who will be purchasing it is buying the property with a ton of risk of potential litigation in the future.
Exactly. Someone else coming back and claiming and maybe even winning in court and getting to take that property back.
Right.
Another reason that I see a lot of quiet title, not a lot of them but the occasional quiet title issue is because someone has sold the property, they have done it themselves, recorded the deed themselves, they didn't get title insurance, which they're like, why do I need title insurance? Waste of money. However, then when that buyer goes to sell the property, the title company will not, because that previous deed was not insured, they won't insure the next deed, and now they don't have marketable title. So then we're running around trying to find the person who gave that deed, but heaven forbid they be deceased or just we can't find them. I mean, we found people in other countries. We've done all kinds of things to track these people down. But in the instance that it's either can't or it's impossible, for obvious reasons, that's when we have to call you, because now we need the court to say, okay, yes, this person, that acquired the property without title insurance is the rightful owner and their title should be marketable. And so, and that can take a year.
There's something else that comes up a lot with the tax liens or anything that was had a foreclosure process paid for it. If you are the rightful occupant, or you believe you are the rightful occupant, potentially maybe the foreclosure was illegal. And you're saying, no, they took my home, it was illegal. We have a rule here, it's called the tender rule, TENDER rule. And so if you are going to be the plaintiff in that action, you will file with your complaint the money to pay out the person who paid off either the tax lien or the foreclosure costs.
So you're making that person whole. So you're making that person whole again.
Right. The court
giving them the money back.
Right. It's showing that in good faith, if there was a tax lien, I would have paid it. Maybe they had no notice of it. But here's the money for my tax lien. And by the way, here's the quiet title lawsuit. It was an illegal tax lien and they took my property in an improper way. I was never notified of this proceeding. That does sometimes happen as well.
So the person who purchased it through that tax foreclosure, what have you, may not get to keep.
Right. But at least they will be made whole. They're kind of an innocent bystander, if you will, the third party, right?
Right.
So, yes, and like I was stating, that it can sometimes take place with easements, which there's millions of different types of easements. Some are express, some are implied, meaning just over time and use. They have developed property rights to using maybe a road that cuts through somebody's
You can't deny them access to their property.
Right. And there are also express ones that are written in contract that may not be on record that we find out later. And so for those types of easement uses, again, we would do quite a title process.
Very good. Mm-hmm. So if you have questions about this, feel free to give us a call. Kerstan would probably be the one to talk to about that. But, I can answer any of your real estate questions, you can reach me at 702-777-1234. And you can reach Kerstan at 702-501-3442. And that's for my law firm, Essential Legal Services. Very good. So thank you for joining us on Real Estate Today, and we'll look forward to seeing you next time.